the best way to avoid going to court is having the appropriate legal document signed. You want your document to be specific, and you want the document to proactively outline what happens if things don't work out, things get complicated. Hi, everyone, and welcome to another exciting episode of the Conscious Counsel podcast with your host, Cory Sterling. That's me. I'm so happy that you've decided to join. And as always, the promise and the mission of this podcast is to provide information to help you protect and grow your wellness business with both confidence and clarity. That's the name of the game. I want you to have information. I want you to understand how the law works as it relates to health and wellness entrepreneurs. And I just want you to be better and to be able to protect your dream, protect your business, protect your life, do everything properly in the correct way. This week, I'm going to share a story of something that I'm going through with one of my clients who just got served papers and is getting sued. So not a fun situation to be in. And there are a couple of things that led up to my client actually getting sued, which are the things that I'm going to focus more about than the lawsuit itself. But this is really, really important to understand, how do things get to a point of someone actually getting sued in a situation in the entrepreneurial world of the health and wellness industries. And so in this situation, it's actually really, really simple. Most things are really simple. And I've talked a lot about legal position before, and I've talked about the concept of pay me now versus pay me later, that when you invest in law for your business upfront and proactively, that you put yourself in a position to succeed down the road, and that you are in a situation where you can avoid pitfalls or problems or stresses, but also conversely, not setting things up properly, not getting the agreement signed that you know needs to be signed, can lead to a lot of issues and can be a very, very, very expensive problem. So in this particular situation, my client was working with someone and they did not have a service agreement signed. So they were working with their client, they accepted payment from their client, they did not have a specific customized service agreement outlining what's being done, what's included, what's not included, if we create materials together, who owns them. All of these things are the crux of what this lawsuit is going to be about. And it's in the most simplistic way possible. When I look at this situation, now my client is getting sued for $50,000 plus, plus they're paying me a whole bunch of money to help them out and help resolve the situation. So it's significant business expenses that are involved in the process. And it's like, if you invested in one document from the start, you wouldn't be in this problem and you wouldn't have the situation. And now you wouldn't be stressed, freaking out, paying lots and lots and tens of thousands of dollars to have things resolved. So the first thing that I just want everyone to know, it's like the best way to avoid going to court is having the appropriate legal document signed. You want your document to be specific. You want your document to be specific to the relationship that you want to have. You want your document to be connected to the expectations that you have in this particular relationship. And you want the document to proactively outline what happens if things don't work out, things get complicated, we have a disagreement, one of us wants to leave, one of us wants to do something else, whatever it is in any situation. The whole point of having these contracts is that they're able to demonstrate before you started doing something, what were your intentions, what did you agree to, and in the event things didn't work out, what happens next. And so where I find myself right now, I helped this client originally respond to a demand letter. They received a demand letter some months ago. I drafted the response and I was like, look, it's iffy. It can go either way because you don't have the signed contract. And now after the demand letter we sent, we didn't hear anything, but we just got a response back that my client was served with documents and will have to go to court for a lawsuit. Not fun. And again, the point of this episode is I'm going to play it out in two different ways, okay? So the first way is what's happening now. And what's happening now is the client had a service agreement, accepted a whole bunch of money from someone. There were some disagreements about the working process together. There was no signed contract. And now it's just, I'm looking at, the notice of civil claim, which is the document that outlines the basis for the lawsuit. And there's so much stuff there. And it's just going to be so convoluted, so difficult, takes so much time to sort through, where it's just like, if there was a signed contract, all of this would be easy. Anyways, we're not getting to that scenario yet. To continue with this. So now what's going to happen is they sue my client. we're going to have to respond to the claim and refute all of the reasons that they say and say, actually, you're wrong because of this, because of this, because of this, because of this. This situation, it's 50-50. The strength of their legal position is 50%. The strength of ours is 50%. And lawyers will always try to stay away from this sort of situation because if it's 50-50, it can go either way, which means you can lose all of it. You could win all of it. But hopefully there will be some form of settlement or mediation or something that takes place along the way. But just to make this so super clear, if there was a signed agreement before my client started working with this person, there would be no lawsuits. This is the situation that comes up. And when sometimes I'm on sales calls and people are like, oh, you know what? It's a lot to invest in a document and I don't know if I'm ready to invest and I've got other things that I've got to pay for. It's like, cool, I totally get that. And if there's a situation, paying $3,000 now will definitely be worth, $65,000 in the future. And so that's the situation. Nothing signed, 50-50 split on legal position, no great evidence on either side. And it's basically a coin flip and the lawyers just charge more and things get dragged out and become more expensive for everyone. Conversely, how I would have dealt with this situation in the event my client had a signed service agreement. We get a demand letter. Here's a copy of the signed service agreement. This is where we outlined intellectual property, payment terms, no refunds, cancellations, expectations, deliverables. If you want to continue with an action against us, we reserve the right to counterclaim. Okay? Cool. Let's say they still decide to serve us. Hey, cool. Awesome. This is our response. You signed a contract on this date. These are the terms that the parties contractually agreed to. This is your legal position. You have no chance against us. If you pursue this, we reserve the right to counterclaim against you. And then it's just cool. If someone wants to push it, in all of my years of being a lawyer and working in this particular area of law, I've never seen it that someone has a customized specific industry legal agreement that's signed, gets a demand letter, and things continue to elevate. In the different times that I have helped my clients navigate through situations where there's a risk or potential of getting sued, every time it's because they did not have an agreement signed from the start. That's it. That's all that. It's a very, very simple game. So my intention in recording this podcast for you today is just to let you know that, okay, does it happen? For sure it happens. It's very real. It's very possible that someone gets sued and that someone can get sued. Why do people get sued? And from everything that I've seen and all my years of doing this, almost a decade of doing this, people get sued because they don't have specific customized signed agreements beforehand. And that's it. That's simple and basic situation. And what I'm going through right now, firstly, it's not fun for me. I love registering trademarks. I love drafting waivers. I love being proactive with law and helping my clients get set up to succeed. And that's what excites me. I'm also capable of doing this work where I can support clients. I can walk them through the process. I can prepare arguments for them. I can do all of these different things for them. I can do that too, but lawsuits and responses are not fun. It's not good energy for anybody. And no one's having a good time when this stuff happens. So to summarize this week's episode and sort of just bring it in for a landing and tie things together. In the event that you are operating and you have different commercial relationships and you don't have signed agreements for them, you're definitely at risk. And so the best investment that you can make for your business, and this is from all my years of experience, the best investment you can make is invest in documents to protect your legal position. If you're a yoga studio, you have employee agreements, you have waivers of liability, you have studio membership agreements, you have privacy policy, 1099, media release, you set everything up at the start to be protected. So that if down the line, and the same with a coaching business, with your clients, with your team, with your brand, registering your trademark, my inbox is a constant stream of two things. One, a positive, successful outcome because we did things properly, or a negative situation because someone decided not to invest or not to do things properly at the start. And then they end up getting, in the long run, it drains them. And then in this situation, this particular episode, I'm just talking about how it is possible to get sued when you don't have a strong legal position. The biggest deterrent from getting sued is having customized signed legal agreements that created the expectations that you wanted in the working relationship that you had. All I want is for you, the listener, to be protected. I don't want anyone to have problems. I don't want anyone to have to go through being sued. It's not fun for the lawyers. It's not fun for you. It's not a good experience. It's not fun for anyone. And yeah, sometimes the situation is out of our control. And for me as a lawyer, just what I'm always looking for is the signed agreement, the customized industry specific signed agreement. And in this case, we don't have one. And so it's going to take a lot of hours and a lot of time and a lot of money. And it is what it is. And the reason why I record all of this information is so that I hope the message gets through to you and that you understand the importance of this, and also on a daily basis what it really looks like. What it really looks like is you don't have a contract with someone, something goes wrong, you get sued for a whole bunch of money, then you're focused on this for the next 6 months of your life, and there are so many more beautiful things to focus on. So whatever it is that you do, make sure that you work with a lawyer who loves you. And if you enjoy the podcast, share it with a friend and hit the subscribe button. I'm wishing you a wonderful week in legal protection.